Thank you, Bill, and thank you everybody here with us in Florida. And to everyone out in the globe, thank you for joining us. We're going to talk about collaboration data. We're going to zip through, in the next hour, a ton of information on collaboration platforms, information governance, discovery, evidentiary value, and some closing statements. My panel today, the illustrious illuminaries Cecil Lin. Cecil has been in litigation as a lawyer, as an in-house counsel, as an advisor. He's currently the board member and founder of the International Data Law Forum. Cecil, thank you for joining us.
Thanks for having me.
Clinton Sanko is the shareholder and managing shareholder of the Chattanooga office of Baker Donaldson. He's also the firm's AI lead. Clinton and I have worked on a number of cases, and we've spoken on a number of groups before, so it's a pleasure to have you here, Clinton, from that outside counsel perspective.
Good to be here, Dan.
David Gaston is the Chief AI Officer at the National Labor Relations Board. David, pleasure to have you. You and I have had a lot of really good dialogues over the years. We don't always see eye to eye, but we always get great answers at the end.
We do.
So I'm really expecting only the best from you today, David.
Only the best.
So let's talk a disclaimer first. Not only are the comments today not reflective of the organizations that these people represent, they may not even be our own opinions today. We may say something just for dialogue effect and purpose. So we don't hold to anything unless you speak to us later and there's a retainer paid, okay? It's a fast-moving area and we're here to explore it honestly. Having said that, we have a poll to start off with everybody. And for this poll, I don't have the instructions to go online for the poll. Do we have the instructions?
I can read off the information.
Could you please?
What are some of the features of collaboration platforms?
So for anyone online, you have the opportunity in the application to answer the poll. We're just trying to get a feel for what you think collaboration platforms are, because we're going to challenge that or maybe expand it. So I'm watching the clock here. Cecil, collaboration platforms, what are some of the features that you use a lot?
Well, I think it's interesting, first of all, just the definition of collaborative platforms and what it used to be and what it is today, right? We used to think of collaboration platforms, the word collaboration just being a way to communicate with, another party and maybe channel additional resources to work together with them, right? To be able to use the same word processing tool to edit in real time. But now, with collaboration tools, I think it's just really that idea of people communicating and collaborating together on steroids, right? I think we're reluctant to find something that does not have a collaborative feature, as opposed to, companies that at one time went out seeking collaboration tools.
David, is that your experience?
Yeah, I would actually add a bit of context, or rather subtext to it as well, because I find collaboration platforms look far more around topics or people or speakers, rather than a sort of chronological adjustment that we would have in historic or legacy systems like email or text, where instead of looking for information as it might arrive and then trying to stitch it together into a work, maybe you have threading or something, but you're still dealing with that issue. I think collaboration platforms in part help change the way you understand the project, the task, because it keeps all the communications in one space.
Clinton?
I think it's interesting because we all collaborate in different ways in our normal world. These platforms just bring it all into one environment where it's being recorded and happening all together. So instead of looking at what happened on a cell phone, what happened in an email system, what happened with geolocation data, now you have a collaboration platform that's bringing that all into one place and where that's all happening together in that one platform. But that doesn't mean it's any less difficult to piece it all back together when you're dealing with it in the discovery context, but it's just all bringing that together. And I think as we bolt on AI onto all of this, it's going to be another kind of participant in that collaboration, that the AI is going to be an active participant as it's happening and within that environment, which I think is going to be really interesting to watch how that affects the merits and how we look at these platforms going forward.
So we really see two things. We see platforms adding additional features, and we see platforms adding features that allow people to collaborate on the work product. So AI, we have an AI subscription that has a company account where we can share the same folders and same threads as opposed to just collaborating with the anonymous AI. We're actually collaborating with each other in that environment. So here's a stronger definition, perhaps, of collaboration platforms: an environment where people communicate, where they can make content, coordinate their tasks, and make decisions in a single, consistent space. And we see this confluence of content, communication, and coordination all taking place. And here are some of the many types of features that are becoming more and more common across multiple applications. We also see this convergence that everything is trying to be collaborative and everything is trying to address all the channels at the same time, it seems. But let's talk about different categories of collaborative platforms. So, Clinton, can you speak to social media? How is social media becoming collaborative more than it was originally?
Well, I think it's allowing, now we see within LinkedIn, right, you have the ability to share out a video in real time and say, come to my room and check out this video. And so it's creating this contemporaneous communication as opposed to a posting that people are reacting to. It's happening real time within the tool and engaging those conversations. So the social media is picking up on those cues and allowing that real time happening to engage in dialogue and be in real time with a group of people that are available in that moment.
So we see on TikTok, you can create communities, you can follow, you can DM, you can post, you can upload files, you can upload your own video. It's a collaboration platform. David, you use Zoom, I think, a lot at work?
Yeah, I mean, historically, the NLRB has used Zoom for hearings. And I don't know how much we're doing it now, but I've participated. I should also mention I'm lead technology counsel of the National Labor Relations Board. I am, on top of my other job, still a practicing attorney, and so this this becomes important later on. But yes, referring to, we are, yes, using Zoom, and I think what's interesting now is as we talk about the collaboration components, is it becomes a different sort of task to understand the data that's being created and managed, where you have a transcript, where you might have an AI summary, where you might have a recording that can be later exported to other tools. And so putting your arms around that and other tools like it have been pretty principal in things that I look at.
So our next question, we have another poll for everybody on the app, which is, what are some examples of collaboration platforms? And there, we'd like to know which platforms you've actually had experience with. And we list a bunch of them as exemplars. And I'm going to show that for the people here in the auditorium. We have a whole list. And the question is not which one, but which ones do you use? I know at our company, we use Teams, we use Salesforce, we use Zoom, we use LinkedIn. Those are the most common ones we have. We also use Zoho and Box. Meaning there's not just one platform we're using. And all these platforms are offering a lot of the same types of features. So you helped your organization. You were recently with a global fintech company.
Yeah.
What type of platforms were y'all using there that came across your desk?
Well, so what's interesting, I wanted to say, one of the earlier slides just on, collaboration tools, I think is just, for those of you that have, interview outside counsel, you're outside counsel, you're interviewing clients, or you're in-house and, you're working with IT. That's a great list to start, right? To be like, hey, do we have wikis? And you'll be surprised with the answer. And I think it's the same with just all of the collaboration tools in the polls, because our company was a 365 shop, right? And so you're like, okay, this is my domain right here. But all of a sudden, you find out about a group that's using the G Suite, and there's folks that went Box, and there's other folks that went Trello, and we're gonna use Facebook for workplace. And so I think that the examples of technology, particularly collaboration tools, within a company is such a dynamic endeavor, right? I think at one point, I was with PayPal. I was with PayPal for 12 years, and I think at one point we've used almost everything on this list. I think maybe with the exception of Fortnite among us. And
Fortnite, you can play the game, you can chat,
but we did use eBay.
You can send messages, you can make teams. It's very collaborative. Oh, by the way, I should explain, the picture here of the Mr. Potato Head family represents different collaboration platforms that have some of the same features jumbled up.
Can I add something to this? So frequently when I've talked to attorneys at my agency and they're, when I'm drafting subpoena instructions or motion or anything, and the first thing that I often ask is like, David, can you just give me a list of all the platforms? I want to put them all in there. Give me a list. And that's usually the beginning of a problem, because now I need to like educate on the topic that you need to start finding the data where it is. You need to start finding people doing what they're doing. And you can't walk into an assumption that a business functions in an information climate or life cycle the same that you do, or the same that of the last entity that you prosecuted against. And so that turns out to be, so a list like this is great because it gives sort of at once it's order because it's a list, but it's also chaotic because imagine Call of Duty being a collaboration platform. It's not if I'm on it, but.
Listen, I got to ask, follow up Cecil's comment. At the NLRB, you're using Zoom for trials, for hearings.
Yes.
It's a collaboration platform. You can have chats and comments and upload files and breakout rooms. Maybe y'all should use Fortnite instead. It would be more effective.
If it was a Call of Duty, if it was a Call of Duty match, and just listen, go for it. 1v1, first to 3. That's a quick justice.
So one of the questions that's come up is, why are these platforms seeming to consolidate around the same features? And some of it is user-driven, but some of it is financially driven. There are incentives for companies to create network effects, to create communities, to get more people to join, to own a community. And so we see this feature creep where channels that used to be solo just for video, just for email, just for documents, now are adding all the same features. I didn't expect I would need chat with my CRM system, but Salesforce is very effective for chat.
I'm seeing this too with some of the newer AI platforms. Like you think about like the major legal platforms, they incentivize you sharing out your work product. They incentivize inviting coworkers in to see your prompts and to see your prompt libraries or to see the vaults that you create where you can engage with materials. So seeing somebody else's conversation triggers work product that you might not have thought of in these newer AI tools as well. So the AI tools are kind of drawing us into a different kind of community, one where we're sharing our work product with the tool and seeing what everybody's doing. But I think those features are going to continue to enhance, and we're going to continue to see teams gravitating towards those platforms as a way of sharing ideas, sharing prompt libraries, sharing workflows that solve particular problems within those teams. And so that's just a different type of community and a different type of collaboration, but one that is incredibly powerful because the back end of that is now really focused on that AI component and that work product component.
Now, typically, discovery and litigation is the last thing people think about when they think about tools and productivity. So we're going to keep that for the second half. I want to ask Cecil first. Cecil, you were responsible for all sorts of technology deployment. Talk about information governance and how that plays a role in evaluating or choosing or deploying these systems.
Yeah, I think information governance should be at the forefront when companies look at what systems are bringing in, the collaborative nature of the tools. Tools generally don't collaborate with themselves. There's usually some cross-platform capability, whether through integration or API. But usually information governance is the last to learn about it, right? Technology spins it up, the business starts to use it, it becomes instrumental, and then somebody will say, what's the retention policy on this? You're like, on what? And you can put these collaboration tools into very broad buckets and say, okay, if it has this type of communication, we're going to save it for X number of months or X number of years. But more and more, particularly with AI, right, we're seeing people aren't really collaborating with other people, they're collaborating with themselves.
Wow,
right.
That's powerful. Judge Artigler, do we have a question from the audience?
Yes, there's a question from the online audience, and I don't know if this is answerable, but if it is, this group can do it. Okay. Do you think that the developers of these collaboration tools purposefully make it difficult to export the information for legal purposes, or that it's just even in their consideration as they develop the products?
Clinton, what has been your experience?
I would say I don't think that it's an intentionality to make it difficult. I think that they architected around the features and the sets that they're trying to do to make it really powerful for the user. And I think that data extraction and e-discovery tend to be a back-end thought that happens over time. I mean, we saw this years ago with the electronic medical records. They developed the electronic medical records, obviously, to provide care to patients, to look for indications, leading indications that the medical staff may miss, and they develop all these things. Well, when you try to export a medical record out of that, that's a very difficult thing to get into all of the different logs, but those logs weren't created for discovery, they were created for medical care. So I don't think there's an intentionality to make it difficult for discovery. I think it's an intentionality to make it serve the purpose, the business purpose that it wants to serve, and we tend to have to deal with the fallout of that on the back end.
I would also add that until a few years ago, we just got lucky, right? No lawyer really sat around thinking like, oh man, I wish there was a PST file that would have all of the metadata as a wrapped container file where I could put it in and be a searchable asset, and then also have TCP/IP data where I could check the hops against Greenwich Mean Time. I would have these forensic assets for email. People just used email, and it happened to be that the back end was a highly mineable, I guess, a highly enriched data asset for forensic intelligence. We just got lucky. I think there was never the point, and I think we're now paying for it.
I think another aspect of it, again, I agree. I don't think companies intentionally try to make it difficult, but I do think that as somebody that's looking at these tools, there's a couple of considerations you have to look at. One is the maturity of the technology, and the second is the maturity of the company, right? So if you go to a Microsoft or Google, they're gonna know, before and within the development of this, we talk about, in a different context, privacy by design, right? We also talk preservation, by design, to have these, built in and baked into the tools, right? And some young companies may just say, you know what, we have an API, let somebody else build it, right? So your company is excited about the product, but all of the back-end preservation process, even information governance, is now somebody else's problem, right? So I think you have to look at really the maturity model of the company and the technology, which will help you, figure out what the path for preservation and governance is.
Well, I think it's an afterthought. Famously, some of the larger companies like Meta had rooms and floors of lawyers answering subpoenas, and then they started building in self-service DIY capability to export your data for collection purposes. And we've seen that feature grow later after the emergence of platforms. I think there's also an economic incentive in some cases to not make it easy to export all your data, because if all of your movie history is in Netflix, you can't migrate that to Apple TV, so you got to use both. And I'm not suggesting that I know their business strategy, but it certainly makes it difficult to switch tools when you have an invested content that you can't migrate. Great question from the audience. So as we talk about information governance, Cecil, we've talked about having management versus in place, managing your data, versus pulling it into a sandbox or a war room. So we have a war room picture here. Dr. Evil. Every tool doesn't need a war room, but it needs a plan. Tell me how you put plans around your packages and tools when you deploy them for information governance.
Well, it's a great question, and the one thing about information governance that you really have to figure out, right, is whether you're going to have centralized information governance, like with one group, or you're going to empower the organization. To be kind of the backstop for, retention. And I think it's a better opportunity to, engage the entire organization. So, information governance is a part of the conversation in terms of what tools are going to be onboarded, what the features are, what the maturity level of the product is, and also involved in what the plan is going to be. Does it align with an existing retention schema, or is there a reason not to follow a particular retention schema, right? It fits perfectly into this category. The retention for this category is 12 months, and people start screaming, no, we can't have this data for 12 months, right? So you've got to start really listening to the business owners, and pushing back a little bit to say, hey, look, information is information, right? And how we use that information to plug and play into a particular retention category is really an important consideration. So
Clinton, you approve technology for the firm, and you're also involved in collecting data from litigants. One of the things we see with these tools that have lots of features is there's lots of configuration choices. Do you store your chats in Zoom locally? Do you store them centrally? Do you store your data in OneDrive? Do you store it locally? When you have all these variations, talk about how that makes the challenge worse or better. Do you sometimes wish that employees had no choices, they all had to use it the same way?
Of course, I mean, everybody would love to have everything all in one nice, neat spot, but that's just not the way that corporations work, and it's not the way that a law firm works. I would say that we have a very multidisciplinary approach. We have a security team that looks at the security implications. We have a privacy team that looks at the privacy implications. We have an InfoGov team that looks at that side of things, like what's it going to take to store, and then we have like the business realities of what we're trying to do. And I think kind of driving that is our general counsel office that would look at what makes sense for our business, what makes sense for our clients, and and all of those different things. What I was going to add to this is at the bottom of the slide, it said standard collections are a thing of the past, and that is absolutely true, and we're going to get to that in the discovery context because these systems are just developing. But the other thing is like all of these tools, you buy them on day one, and by day 360, they are a completely different tool with completely different things being stored in them because the tool that you bought a year ago is not the tool and the functionality that it has now. And so the categories change over time. So it's a constant revision and constant rethinking about retention, and how an organization does that is going to be driven a lot by how those features get rolled out, who has licenses to it, and all those kind of things. So there's just a lot of complexity right now because we are in a world of just constant development, which is super fun as a user as I get into my tools. And they're always different. Like, this is awesome. You put your, your firm hat on or your InfoGov hat on, and it's a little daunting to think about what that means. So the point being for everybody is when you engage in discovery, you have to kind of look at the tool and what it is right then and what it will have that relates to the merits of your suit. We have a question back here.
Yeah, this is an online question. It's getting a lot of interest also online. And it has to do exactly with what you two have just been talking about, which is setting forth certain tools that the company, I guess, says this is okay, we'll use these and so forth. But how do you manage the use of non-company and unsanctioned collaboration tools for discovery purposes?
I'm going to turn to Cecil for that.
Why don't you turn to me?
Because you would have had the biggest
because this comes
challenges
up. I mean,
for that.
This literally comes up, right? And it comes up a lot, I think, in companies. Like, as much as companies like to think that they have all technology walled off, this comes up kind of in a sanctioned and quasi-sanctioned, right? And the sanctioned obviously is a company is, with a particular business is building something, and there's a tool that's tailor-made to help them do that, and they bring that in officially. Another kind of quasi is, acquisitions where you're bringing in, you acquire a company and they're using technology that perhaps, you didn't know about and it wasn't particularly vetted. I think the answer is the same, is that you need to get, into that technology and find out as quickly as you can, right? What the path to preservation, I call it, is, what the path to retention is, and whether it's organic or whether there's some third-party tool you've got to deploy. I will say, 9 times out of 10, there is a path, there is a process, but it's very much a training opportunity as well for those groups that are using unsanctioned, if you use that term, tools.
We have a question in the audience, but first I want to ask Clinton a question. Clinton, as a lawyer, you work on many cases with co-counsel. Can you dictate the platform you're using if you want to collaborate, or sometimes you have to use what they've chosen?
Of course, you have to kind of work with the team as it comes to you. From a standpoint of kind of thinking through that question, one is policy, right? I mean, having policies and standards that your employees or your lawyers in the context of a law firm are required to follow. So we have policies at our law firm about what tools you're allowed to use and for what purpose. And if it has to do with clients or it has to do with firm confidential materials, it has to be through sanctioned tools, and there has to be some consequences for employees or professionals that don't follow those policies. For a client, as a litigator, you take your client as you find them, and if you have a employee that used a non-sanctioned tool, you have to deal with that, just like we have had to do for the last 10 years. And the most common example, in my experience, has just been their mobile device. If they've done work on their mobile device and you learn of that as the outside counsel, and there is some relevant information and it's their private device, you have to have some ways of dealing with that, and it usually starts with looking at the client's policy. Then it usually starts with talking to the custodian about what that means, and think about, like, how can you go get that information in the least intrusive, least invasive way, but satisfy the discovery obligation. So we've been dealing with these questions for a long time. It's just now they're in these different kinds of tools that are much more powerful and that can spit out a lot of different kinds of results.
We actually have more than one question from our studio audience.
Hi,
Who? Could you introduce yourself?
Oh, hi, Rachel Fernandez. I'm from Sandline and a vendor. So obviously I'm a little biased in terms of exporting data. But Cecil, you described quite a bit of information governance and importance in setting sort of these parameters when investigating a tool to use. And to Clinton's point, e-discovery is often a reactionary measure to those policies. So to marry those two concepts, should part of the evaluation of a tool when setting an information governance policy around it consider e-discovery and ease of export?
I think that tools, when tools are brought for consideration, that a big part should be, the ability to manage the data within the tool, right? From an information governance perspective, right? From a record retention, from a preservation standpoint, right? From just a data general governance perspective, which I think includes e-discovery. I don't think that necessarily the management of the data is reactionary. I think it's proactive, right? Because I've got to have a way to manage the data. And so I have to be thinking about, right, what repository this data is going to go into, how I'm going to be able to export the data from that repository, what happens if I need to retain it, what happens if I need to split it off, like for example, if it's customer data, right? Maybe some data I have to keep for retention purposes, right? There's other data I'll have to keep for litigation. So I think all of that comes into kind of what I was talking about, to really look at that as systems are being onboarded for the variety of different types of retention and preservation that you'll need.
Sort of a Dr. Stephen Covey, start with the end in mind. 7 Habits of Highly Effective People. We're not being effective today. Yeah. We have another question from the audience.
Ashley Picker-Dubin from Dave Pitney. We've talked a lot about the information governance of current employees. What about departing employees subject to lit holds and how you're addressing that data, especially when it comes to non-system data? So either mobile device or non-mobile device management or system management tools or products. And are you collecting it in advance, or are you relying on custodians to enforce their own hold?
So the question is, we're switching to devices from platforms, or platforms on devices?
Platforms on devices that...
And whether or not custodians who are leaving the organization have been trusted to preserve their own data, or we take extra efforts to enforce retention.
And whether that's taking place during the course of offboarding, which frequently doesn't involve a legal team.
So that's a question that's almost worthy of its own session.
That's right.
But I'll see if Clinton has a shorter answer for us.
Yeah, so departed employee decisions a lot of times are almost made de facto when you put your legal hold down. Like, how important is that information to the scenario that you have? And so if you have a fraud case or an antitrust case, a lot of times, you're dealing with a legal hold that goes down on day one, and then you're looking at cell phone or mobile phone collections and those kind of things that would be device specific for those custodians at that time. So like, you're looking at those questions and you're doing that proportionality analysis at the time. If it gets to an onboarding decision, decision, an offboarding decision, and those offboarding processes, like that is obviously an area where we all know that that's a major gap that can happen if you don't have a good employee listing, so that their shared drive and their email and their computer doesn't get recycled. So those decisions should be made to make sure that that departed employee list is being followed, that the IT is in the loop on all of that. But in terms of like what would be important that custodian individually would be managing, like we would try to deal with that at the time that they're still a current employee, when you can make those forward-looking proportionality decisions and say, should this be something we collect? And then a lot of times, obviously, there's certain types of information that we do rely on the employees to maintain, depending on the proportionality analysis that's done and working with the client on what the risk and the goals of litigation are.
Do we have another question online, Judge Artigler? Okay. So we have another poll, just real quick. And I ask, show of hands, how many of you have had to collect data from a collaboration platform for discovery? So now we can go into the discovery part of the conversation.
Dan, for the online audience, how many in the room?
How many in the room? Everybody seemed to raise their hand. If you didn't raise your hand, we're going to purposely not call you out by name. Let's talk about discovery. And Clinton, I want to start with you, but I want to let Cecil and David also weigh in on this. Tell us about discovery when it comes to these collaborative platforms. What are the challenges?
The first challenge that I see when we're thinking about collaboration platforms is ferreting out if they exist and if there's information on them that could matter to the lawsuit. And so again, this is a initial decision. You get a piece of litigation and you're working with your in-house team on the goals of litigation, what's really at stake, but you have to figure out what collaboration platforms could have information that relates to the case, what is the information governance retention on them. And really the way that we mostly find effective to do this is, number one, talking to the IT environment about what is available, what is possible in their system, what they've done, what their information retention policies are on those systems, and then talking to the actual witnesses that have that information and talking to them about where those channels might have occurred, where that collaboration might have happened, and dealing with those right at the beginning of the lawsuit so that you know what's coming down the pike. Then you can start that process of talking to the IT people about what success have you had putting legal holds on that system? What's the capabilities? Because as we saw with the slide about collaboration systems, every client is different. There's so many different possibilities. You have to look at that system in the context that it's in, the importance of the litigation, and make some decisions about what you need to do proportionally to retain that for preservation purposes.
I think you and I are having a discussion about a client who used AI tools to transcribe every Zoom call the company ever had, but looking at the statistics, had never used a single transcription, but still had it available and part of discovery.
Yeah, and in that setting, you have to look at kind of like, what's the reliability of that evidence? What would be important to the case? I mean, obviously, you wouldn't have to put a legal hold down on every Zoom conversation, right? It would match the merits. You would look at which custodians would be important, which meetings might be important. We've had this come up in terms of training videos, right? I mean, like, there can be training videos that are very collaborative that have like a training element to them. How do you put a legal hold down? Well, you don't put it on the entire training system. That wouldn't be proportional or smart. Instead, you look at what would be relevant to the piece of litigation, how you go about finding those, and then identifying what's important. It would be the same with the Zoom transcripts. You probably want to hold, but you'd also want to understand what organizational value that has to the litigation and start to prepare some of your admissibility questions and some of your arguments about what's proportional to even go collect or search for that information.
David, in your role, both as a practicing attorney at the NLRB, as well as the AI chief.
Yes.
On the attorney side, what type of systems do you see enter into the evidentiary corpus?
Well, it's interesting because, to kind of re-stress of impact that, it changes so much on who we're going after and what we're going after them for. And so I found, I won't name the company, but I found an interesting break. It was about 8 years ago where I was going after a company. We were enforcing the law. I was going after a company and I was asking them, hey, your principals, how do they communicate? And they said, well, we want the emails is what we said, but they want the emails. I said, no problem, we'll give you the emails. And they gave us, there was a bunch of fulfillment centers overseas and it was just garbage. And then finally it became clear that they were using an in-house bespoke solution for the actual principal communications. And we had to go backwards. And then, there's the rule 34E3, you don't have to produce something more than twice, and all that kind of stuff. And so it turned into a big mess based on the fact that if you can't even anticipate like what was on that list, for instance, because a lot of the large organizations, many of whom I'm sure are represented by proxy or directly here, have built their own tool, and they'll have like, widget chat, and Widget Co will use widget chat, and you need to make sure that you're engaging those questions directly. And so to give a shorter answer, it depends.
Actually, we had a case where we had the opposite. The client did produce their communication platform. They were using Basecamp with long threads, and the other side said, well, where are your emails? And they said, we don't use emails. And they didn't believe them. They said, you have to use emails. I said, no, we don't. So it was also a challenge in the other direction.
It's a consistent problem where I'm dealing with attorneys on my side who think they understand how data works, and it's like, listen, like no one does things like we do it. The government has an entirely different structure on how communications are managed and a different rule set of what you're trying to resolve.
So Clinton, you brought up proportionality. You've used that phrase several times. Would it be proportionate to pursue that or preserve that? Let's dig into that a little bit more. Is it possible to overcollect? Is it possible to undercollect?
Of course it is. I mean, in these contexts, these tools have a lot of contemporaneous information that may have nothing to do with the merits of the lawsuit. And there's just always a question of how important is that evidence to the issues at stake in the litigation, right? So we're constantly investigating. You say to yourself, like, you see a Teams channel that could matter to the piece of litigation. Do you need the whole Teams channel? Maybe you do for context, and in that case, sometimes it makes sense to collect that. Do you need the contemporaneous version of the attachment that they were talking about, or the hyperlink that they were talking about in that moment? Is that actually important? That can be, but maybe it's not. And understanding kind of how that fits with the litigation, what the merits of the litigation are, is super important for understanding what level of effort needs to go into the collection that you have. Because a lot of times if you just need a specific communication, I mean, it's very possible with the cell phone, as we all know, you can take a screenshot of a particular text message and produce that screenshot, right? And that shows everybody what that is. Is that effective if you run it across 1,000 text messages? Not usually. So that's usually a place where you involve a vendor and you make that production a little bit differently. And these systems are no different. They just have this complexity of these bimodal different communications that are happening within them that have to be married or not, depending on how things are going. And so when we look at it, we're always looking at like what's necessary for this piece of litigation, what's proportionate, how much is really, what level of effort, and a lot of times that is partnering with the IT and a lot of times with a vendor to come in and help us get a defensible collection based on all those different things that we're weighing. And potentially discussing it with David and the opposing party, because it could very much matter to them, and you're trying not to have repetitive effort there as well.
So I want to leverage off something you said and bring a question to Cecil. You talked about bimodal communications, multimodal communications. It seems that it's not just that you have a chat application in your operating system and an email and a video. Is the fact that they're all together make it more likely that people will communicate using more than one mode simultaneously? Do we have a context issue where we need to pull the chats because they're more likely to occur while the video is happening? They're more likely to occur while files are being shared. Is there a multi-layer, is there an increase in the need to consider the multi-layers because they're built into a single platform?
So there's a couple of things there. I think number one, it depends on the actors, the players, the custodians, right? And their sophistication or how much they want to play in the sandbox, right? Because, we do see that. We do see a lot of people that will start on one platform and then marry in another platform, right? And then the second consideration is, what type of case is it that you're looking at? Is it a litigation? Is it, an investigation? Is it a regulatory matter? Because that, the type of case generally tells you where the data is and what type of data you're looking at, right? And so, I think those two things, again, they're independent, but they go hand in hand. But to answer your question, even more specifically, I have been involved in matters where, you have to find the object that they're discussing in a chat, right? They're talking about something in a chat, but you don't know where it is or what it is or how it exists. And, it goes back to what we talked about earlier. It's collaboration isn't just about technology. You can pick up the phone and ask them, hey, what is that you guys are talking about?
Well, we've had cases where the insiders have their own lingo, and you don't know what they mean because you don't know the inside jokes. But when you take those text messages that look harmless and you realize they were in a meeting with their boss or subordinate, suddenly it has a whole different meaning. I'm not suggesting that anyone out there is texting about us right now.
Okay.
Right? But
Privileged. It's all very
it would add some context to it. That's what you and I were talking about, Clinton, the context aspect. We see here, proportionality is no longer just about volume. It's about the contextual sufficiency, the layers.
And this happens in regular discovery as well, right? We're talking about it in the context of collaboration tools, but we had a case recently, it was a trade secret case, and there was a big question about whether a witness opened a particular attachment. And the witness put a declaration down and said, I did not open this attachment. So we went to the Microsoft logs, and that didn't really tell the whole story because it was on his mobile device. And so then when we started piecing together the evidence from his mobile device, there was geolocation data that showed the sender was in the same place as the recipient, and that they were talking at the same time, that they when they left that meeting, that they opened up the parent email twice during that same meeting where they were sitting with the sender, makes it much more likely that that was happening. So that contextual stuff, it matters when it matters, but sometimes it doesn't, right? But when it matters, it does, and it's no different with these collaboration tools. And when it does matter, it's an understanding of how that information is being stored, how you can extract it, how you can make those connections in the most efficient way for the litigation. And a lot of times that does involve finding and engaging the right vendor to help you do that process, because that tends to be highly specialized based on the system.
So David, when we got ready for this panel, we talked a lot about the evidentiary value of collaboration tools.
Yes.
And their contents. Can you speak a little bit to the evidentiary value?
Yeah, so when I'm looking at collaboration tool information or any other information, I'm always filtering it through the context of storytelling. And so within that narrative, where does this collaboration information sit? And in my experience, I found that you have about as long as a judge takes to hold their breath to explain the technical components behind it. And if you cannot explain it that quickly, then you need to come up with another strategy. And so when it comes to this information, I'm always targeting not just what the information is, but who said it, when it was said, what was the context of it being said, where was it said, can I present it in a way that looks familiar? Like getting an export from a Facebook is great, but showing a Facebook page with a thumbs down, is far more persuasive when it goes to indicating what the story you're trying to tell is using that collaboration data. So I think that's the sum of it.
Clinton, evidentiary value of this data? What are you trying to bring out to the trier of fact?
Well, again, it always goes to how important it is to the issues at hand and how much the opposing counsel is pushing for a particular type of format. So we're always talking to the client about what's reasonable, to the vendors about what's possible, and then to the opposing counsel about where those meet based upon the evidentiary value, because that's one of the things that we're negotiating. We're trying to get to a proportional discovery plan with all of our plaintiff colleagues. How do we get there? If that's a really important thing to David, that it's pulled in a particular way, maybe he'll give a little bit on the search terms on the other side. So thinking about it more as holistically, how do we get to a defensible, compliant production? So why? So we can move forward to the merits and actually try the case and not have it devolve into a discussion with the judge about what's, kind of how we extract a particular piece of information. So it's really looking at it holistically, where it fits in the case and how important it is to.
We're not using search terms anymore. We're using AI.
That's that is definitely a different panel, Dan. We have a question.
Aaron, yes. With the mic him up.
The suspense is killing us. We have an audience question. For the online, please tell us who you are.
This is a comment. I'm Aaron Amadi. I'm the head of AI relativity, but I'm actually going to take my relativity hat off for a second, actually just comment more broadly as an AI technologist in the space. There's kind of two forces that we're going to see in here. For those of you who are kind of paying attention for the last couple of years, we really saw a disruption in document review through generative AI, because it sort of, I don't want to say became obvious, but it's becoming more clear to people that document review is something that is within the boundaries of what a generative AI system can do. What's emerging in 2026 is that agentic systems are going to be really, really good at investigations, right? And this is not here yet; it's coming. And the reason why they're going to be very good at this is because they're not actually that smart. And people always think that like AI is very smart. It's not that smart, but it's really good at pattern matching, and it's really good at following instructions. And it's really good at doing lots and lots and lots and lots of, I'm going to say drudgerous work. I think when you're an investigator, I think you get excited about some of the things that you're doing, but it does a lot of the drudgerous work. So 2 key points that I kind of want to leave this whole group with. One is that there is a shifting frontier, and investigation is one of the places that we're going to see a lot of interesting stuff come about. And the second one is that there is this hunger for data that will only grow as these systems become more capable and they reduce the cost of an investigation. And they're going to want to know every little detail that they can. Okay,
well, you're going to say, those are great comments for a different session on solving the problem.
No, I'm not, no. This is just about I'm not saying that we're going to solve anything. I'm just observing that there's going to be an increase in asks for more data, and that there's going to be confidence from some group that they have solved this. I don't know if they have or have not, but I think you're going to observe both of those things, just broadly as an industry.
Okay. Let me come back to our group here. We're still, before we were applying agentic AI, let's go back to the collection of this information. It seems that we used to have fewer people using technology and that weren't using it consistently, so you could have discrete packets of an email, a communication. Then we started moving into people using enough technology, it seemed like they were constantly engaged with technology. And now with collaboration platforms, we see within a single application the opportunity for constant engagement. Is that a fair characterization of the growth? And so the challenge is pulling that data out to tell that multi-layered narrative, David, and present that to the judge. When you talk about the narrative, are you talking about the narrative of why you need the data, or the narrative you're creating once you have the data?
Once we have the data, and just to add a little bit more to that, I think there's an opportunity for philosophy as we think about these ESI questions, and there's a balance between order and chaos, and I think we're trending away from order and trending towards chaos in terms of having to go to all these different tools. I've used screenshots. I don't like screenshots, but sometimes that's the best evidence. Or the video where you go through the chats. You know, I don't like doing that. And so because the evidence is getting more chaotic, it's getting tougher to understand, it's getting tougher to explain, it's getting tougher to validate, and we have a competing source of generating information that we haven't got our hands around yet. Then the story becomes even more important, and to being able to say this happened, and so I think there's a matrix, or rather a nexus, between the value of information that sits as a forensic value and just the people value. Judge Grimm mentioned earlier that our judicial system is built around testimonial, around juries, around people saying things that they saw, right? There's a rule against hearsay. It's hundreds of years old. We don't have a rule against AI yet. So, yeah, so people would like to make it, probably at me. So that's what I'm trying to say. And so moving it more towards the testimonial component, I thought is also successful.
So what I'm hearing is collaboration tools are collecting a lot more data, and that's valuable, but it's also a challenge to get it out.
It's tougher to present. It's tougher. You have a lot more rocks that are shiny, but it's tougher to present a diamond.
So this has been a great hour. Let's talk about some takeaways. Clinton, takeaway number 1.
I think we all have to be curious and practical in our application of these tools. Curious about what the case needs and what makes sense for it, and practical in the sense of, you know, kind of how are we going to present this? What are we going to use it for? Where is this going? And part of this just thinking like our trial lawyers think, like, you know, how are we going to prove our case? But being curious about the systems, and then practical about what makes sense to solve the problem of producing it and moving past that to the merits.
David, a takeaway for our audience today.
Be prepared for worse. It's going to get worse before it gets better, and it's getting worse. I mean, the point is, I guess the easiest takeaway is don't presume you understand this information, because these tools are evolving at such a speed that that you need to make sure you're doing the requisite research
Confirm,
before.
not assumption.
Yeah, that's it.
I like that. Cecil.
I'd say, again, stay on kind of the information governance track, right? That, don't assume that your data set and that your organization's technology is static. It's dynamic. So you've got to go out and you've got to be, really, you've got to have that ability to go out and look and find out what the organization is looking, and have those conversations about, again, we talk about privacy by design, but really information governance by design, and make sure you're baking the information governance and the collection and the preservation capabilities into these tools as they're being onboarded in your organization.
So all the features will consolidate and the world will become one giant collaboration platform. And it's going to be worse before it gets better.
Called the Matrix.
Thank you, everybody. You're a great audience.